The title of my article to the OpenSBO review is Fighting Climate Change Through Constitutional Law, the decision of the German Federal Constitutional Court on Climate Change 2021. Climate change protection and environmental law. Ecology as a community problem or as a political question is a reality of our times. Such a modern idea dates back from the crisis of the welfare state model, which appeared at the end of the 60s and whose most acute symptoms were felt in the 70s with the so-called oil crisis, which forced to a general awareness of the limits of economic growth and depletion of natural resources. The crisis of the welfare state would bring about the emergence of the ecological question, just as the social question had emerged from the crisis of the legal state, showing that environmental protection should be seen as a problem of society requiring a political solution. Nowadays, the environmental theme acquires an even greater daily relevance due to the phenomenon of climate change. For the by all felt instability of the climate, accompanied by the growing awareness that this is due to human action, reintroduces the environmental issue in the daily life of individuals, irremediably removing old resistance or new skepticism. Indeed, families who see their beach holidays ruined because it rains all summer, winter sport practitioners who do not find snow in the usual places, travelers who go to a hot country and encounter a polar cold, or to a cold country and are surprised by tropical heat. People have got used to looking at the street or listening to the weather report to know how they should dress, since there is no longer a proper clothing for each season, can no longer remain indifferent to environmental problems. Answer, both the issue of climate change and in general all environmental problems have become must-talk topics, from coffee shops to media news, from films to Hollywood Oscar award ceremonies, from school competition awards to the Nobel Peace Prize, from political parties to non-governmental organizations, from local political agendas to major international conferences. And the theme is indeed important, and indeed it's severe, because the climate change situation requires immediate action from the governments, from the states, from Europe, from the global community. If we keep on non-complying the Paris Agreement, we are in a terrible, we can be in a terrible situation. Not wanting to be catastrophist, I quote something written by Liu Kemp, a specialist on environmental questions from the University of Cambridge. It says that climate change could lead to a meltdown of world society and even to the eventual extinction of humanity. That could be a catastrophic outcome if there is this non-compliance of the agreed rules of the Paris Agreement and other treaties and other international decisions of the global order. But let us look now at the decision of the German Constitutional Court on climate change. We are assisting nowadays of the intervention of some courts, mainly constitutional courts, in this issue, because the complainants go to the court saying there is not enough compliance of the international regulations, there are violations of the constitutions, and the Constitutional Court needs to take a position about it. And just to talk about some of this experience, it happened in Brazil, it happened in Germany, it is going to happen now because there is already a demand in the European Court of Human Rights. But the German Constitutional Court is pioneer. It's one of the first sentences dealing with that problem, but it is also a highly innovative judgment. It's indeed a green global environmental law court decision. And it's something that we have to salute is the outcome of this situation, of this complainant that was standing in the Constitutional Court of Justice. The conclusion of the decision were like this. Some of the norms of the Federal Climate Change Act of 12 September 2019 are incompatible with fundamental rights insofar as they lack provisions on the updating of reduction targets for periods from 2041 that satisfy the constitutional limits. They say that the court decides there is a violation of the fundamental rights, and here is the fundamental right of the environment, because the law does not review provisions adequate to protect environment from 2041 on. It's not just the actual provisions, it's mainly the future provisions that are unconstitutional. And we need to look at the reasoning of the court. And in my view, that should be done according to 5 key words, 5 reasons that are pointed out by the Constitutional Court, but should be discussed in a more global dimension. And these 5 key words are as such. First of all, we are in front of a global environmental law court decision. And that means that climate change is a global and a state constitutional problem and has to be dealt in these levels. The second is that human and fundamental rights are equal. The third is that the protection of fundamental rights of the environment exists in the German Constitution. The fourth is that the fundamental right to the environment is a right of action of public entities. And the fifth is the conceiving, it's a way of conceiving the right to the environment as a right to and as a right for the future. First, the global environmental law must be considered in the action of a constitutional court. And the court expresses this view in 2 dimensions, into different arguments. The first is declaring the existence of constitutional duties of action to German authorities in global constitutional law order to protect the environment. So, duty to act to protect the environment in the global constitutional law order. And then the court says that foreign citizens, in the case citizens of Nepal and Bangladesh, should be allowed to stand in front of the Constitutional Court in order to complain against violations of fundamental rights, because they are persons, which is indeed remarkable. First, constitutional duties of action of German authorities. The court says, as an obligation to take climate action, Article 20A of Constitution, as an international dimension. The fact that no state can resolve the problem of climate change on its own due to the global nature of the climate and global warming does not invalidate the national obligation to take climate action. Under this obligation, the state is compelled to engage in international-oriented activities to tackle climate change at the global level and is required to promote climate action within the international framework. The state cannot evade its responsibility by pointing to greenhouse gas emissions in other states. This is something that is really decisive. The rights of action of public entities, namely the government, to protect the environment is not just a national one, it is also a global one, and that require adequate measures from the court. But the court also says that some citizens, foreign citizens coming from Nepal and from Bangladesh have their own right of standing before the Constitutional Court to defend their own fundamental rights. Says the court, the complainants can in some cases claim a violation of their fundamental right to life and physical integrity. And some of them can claim a violation of their fundamental right to property, because it is possible that the state, in adopting the Federal Climate Change Act, might have taken insufficient measures to reduce greenhouse gas emissions and to limit global warming. The complainants are not asserting the rights of unborn persons or even the entire future generations, neither of whom enjoy subjective fundamental rights. Rather, the complainants are invoking their own fundamental rights. Nor are the constitutional complaints are an unadmissible actio popularis. The mere fact that very large numbers of people are affected does not exclude persons from being individually affected in their own fundamental rights. This is a step ahead in the constitutional protection of human rights and the rights to a proper environment, the right of a proper environment. Because, as you see, these rights are not the rights of foreign citizens that live in Germany. These are rights of foreigners that live abroad and have a right to stand in Germany because they have fundamental rights in Germany. This is indeed a global law decision. And it goes in the direction I pointed out in one of the things I've written, that since the 70s of the 20th century, it has made sense to speak of green constitutionalism. Because on one hand, the post-social state, emerging from the crisis of the welfare state, brought with it ecological issues, transformed into legal values, both as principles and rights established at highest level of the international and national legal orders. On the other hand, because it is from that moment on that it begins to make sense to speak of constitutional law without frontiers, with the affirmation of the constitutional nature of human rights, including the right to the environment at a global level, and the emergence of the idea of a European constitutional law. Today, there is a fundamental right to the environment enshrined in the global, European, and state legal orders, directly or indirectly. The fundamental right to the environment has its roots in human dignity of the individuals, as actually conceived, and simultaneously presents an objective dimension corresponding to the protection against public and private aggressions in the constitutionally protected sphere, and a positive dimension also creating concrete duties of action or simple tasks in charge of public authorities. 2. Human and fundamental rights are equal. The German Constitutional Court says, insofar as the complainants are natural persons, their constitutional complaints are admissible. They are admissible because they are human, because they have human rights. And this assertion of a protection of the humanity through the constitutional tools, it's something that changes the traditional logic of constitutional law as well as to the international law. Because before, as I written in another text, according to the classical legal logic, both from the point of view of constitutional law and of the public international law, it made no sense to speak in international or global constitutionalism, since international legal relations had states as exclusive subjects, so they were configured as its external relations, while constitutional issues were placed exclusively at the level of the states, being considered as internal relations. Now, the traditional assumptions have been changed. With the internalization of international law and the externalization of constitutional law, which leads to the overcoming of the formalistic distinction between human rights and fundamental rights, all of which are now transformed into human fundamental rights. Nowadays, within the scope of global constitutionalism, in the perspective of the right to an environment without frontiers, it is understood that individuals are autonomous subjects in the international sphere, that the norms of the international order are directly applicable to concrete legal relations, that is to say, at domestic level, conferring true fundamental rights to all individuals, and that such fundamental rights allows individuals access to international courts for the protection of their subjective rights, even against the state to which they belong. But the Constitutional Court decision takes one step ahead. The non-German citizens also have fundamental rights according to the German Constitution. And they have the right to stand in the German Constitutional Court to complain about the inconstitutionality of a German law because of those human rights, because they are human persons. This is a decision, an important decision that inaugurates this era from the point of view of court decisions of global environmental law, of environmental law without frontiers between state, constitution, global constitutionalism, without frontiers, in a protection unified. Third, that decision shows there is protection of fundamental right to the environment in the German Constitution. It is true that the fundamental right to the environment is not directly included in the list of fundamental rights, but he is indirectly protected, and he was created by the innovative jurisprudence of the Constitutional Court, the German Constitutional Court, with the help of the German doctrine of constitutional law. The court says the protection of life and physical integrity Thus, Article 2.2, first sentence of the Basic Law, encompasses protection against impairments of constitutionally guaranteed interests caused by environmental pollution, regardless of who or what circumstances are the cause. The state's duty of protection arising from Article 2.2, first sentence of the Basic Law, also encompasses the duty to protect life and health against the risks posed by a refusal of occur to the application of a fundamental right to an ecological minimum standard of life, or the right to a future consistent with human dignity demanded by the applicants. However, the consideration of this right is a part of the recognized derived fundamental right could be admissible. And they continue saying there is a right to an ecological minimum standard of living that is derived from other things from the minimum standard of living consistent with human dignity. But it can also be based in other fundamental rights like the right to life, the right to physical and mental well-being, the right of property, even in some cases. There is a mechanism for safeguarding the ecological minimum standard that could indeed acquire its own independent validity if in an environment transformed to the point of being toxic, adaptation measures would still be capable of protecting life, physical integrity, and property, but not the other prerequisites of social, cultural, and political life. So the German fundamental law enshrines the environmental protection of the environment in Article 20A through an objective law, which creates a state purpose of objective nature. But jurisprudence and doctrine have, however, admitted control of constitutionality for indirect violation of subjective environmental injuries, either when they take place simultaneously with the damage to other fundamental rights, such as the right to property, freedom of profession, the right to health, the right to life, or when the violation of the fundamental right to the environment guaranteed by international law is at stake, says my good friend Rainer Ernst. Hence, the possibility of considering the fundamental right to the environment as implicitly enshrined according to the creative jurisprudence of the German Constitutional Court with the support of the German constitutional doctrine. And the sentence of the German Constitutional Court reaffirms the indirectly guaranteed fundamental right to the environment and develops its dimension of a right to an ecological minimum standard of living. On the other hand, the content of the judgment dismisses all the claims of inconstitutionality based on objective grounds put forward by the applicants and upholds the arguments based on the subjective dimension of environmental rights. And that seems to me to be the right decision. That seems to me the way we should go. Fourth, the fundamental right of the environment as a right of action of public entities, says the Constitutional Court of Germany. Article 20A of the Basic Law obliges the state to take climate action. This includes the aim of achieving climate neutrality. Article 20A of the Basic Law is a justiciable legal provision designed to commit the political process to a favoring of ecological interests, partly with a view to future generations. That means that the fundamental rights have a double dimension. There is negative and positive. As negative rights, they are rights to defend the individuals from aggressions. But from positive subjective rights, when the war is strict, when there is, as the administrative lawyer says, some vinculation to the action, it creates also a subjective right to an action from the political power. And then there are the other actuation that can be done, but not from the subjective point of view. But from the subjective point of view, there is a right to action when that right is vinculated to the Constitution. And that is something for me that for me has been defended from a long time ago, because in my view, we needed to unify the theory of subjective law from the point of view of constitutional and administrative law, and to unify both of them, as says also my dear friend Hartmut Bauer. And this harmonization must not make admissible in the field of administrative law the existence of rights to action, for instance, of a police in a term, police agent in a specific dimension, or a police authority in certain cases. And these rights of action, there are subjective rights according to administrative law, should be also considered as rights and fundamental rights according to constitutional law. So we need to conceive an expansion of subjective public rights in multilateral relations, administrative or constitutional, and these relations are based on the constitutional norms. It happens like this already in the administrative law, in areas such as environment, urbanism, consumption, competition, policy, and so on. But now the need for dogmatic unification of subjective public rights based on the rights recognized by the Constitution that has borne good fruit in administrative law, it should be transported to constitutional law. Why the notion of fundamental right as a subjective public right continue to be, in practice, restricted only to certain categories of rights? For instance, the first generation of rights in constitutional law, and there is a much broader notion in administrative law. From my perspective, reaffirming the idea of unity of all the subjective public rights, regardless of their source, it is time to draw all the dogmatic consequences of the conjugation of constitutional law with administrative law on a basis of reciprocity, which means that after having followed the path from constitutional to administrative law, it's now also necessary to fall in the opposite decision, from administrative to constitutional law, to rethink the very notion of fundamental rights. Fourth, right to the environment as a right to and a right for the future. Says the German Constitutional Court, under certain conditions, the basic law imposes an obligation to safeguard fundamental freedom over time and to spread the opportunities associated with freedom proportionately across generations. In their subjective dimension, fundamental rights as intertemporal guarantees of freedom afford protection against the greenhouse gas reduction burdens imposed by Article 28 of the Basic Law being unilaterally offloaded onto the future. But the future begins today, because, as says the Constitutional Court, respecting future freedom also requires initiating transition to climate neutrality in good time. In practical terms, this means that transparent specifications for the further course of greenhouse gas reduction must be formulated at an early stage, providing orientation for the required development and implementation processes, and conveying a sufficient degree of development urgency and planning certainty. So there will be an inconstitutionality if we don't anticipate the future. There is a consecration of the precautionary principle also as a constitutional guideline of the fundamental law of Germany. And the court also say that this risk to fundamental freedoms is not unconstitutional on the grounds of any violation of objective constitutional law. It is, however, required by fundamental rights in order to guarantee freedom over time and across generations. Precautionary measures aimed at mitigating the substantial emission reduction burdens which the legislator offloaded onto the post-2040 period with the challenge provisions, and it will then have to impose on the complainants and the others. So there is now, regarding as a subjective right, a right to guarantee the rights of future generations. The future generations have no rights. The Constitutional Court did not declare that. But he also did not declare just that the future rights of the future generations should be protected now from an objective point of view. He says this protection has already a subjective dimension. So that means that fundamental rights, and particularly the fundamental right to a proper climate, a fundamental right to the climate that we are talking about, is something that has to do with the intertemporal protection, a protection that goes through the times. So we need, nowadays, to join past, present, and future. And this combination of past, present, and future is the way of getting a proper protection for the fundamental rights. Or, as the court says, to find a concept of dynamic fundamental rights protection. That could not be more accurate. We need to know that the protection that we are taking of, it's not just for this urgency. It must be a protection that thinks about the future and that is able to guarantee the future of the generations that will be at the time. So there is this idea of an intertemporal protection of human rights, intertemporale Freiheitssicherung, that is a part as a protection of the liberty of the future, as says Martin Brower. And that is something really great, and that is something that a court should say. And I'm in the perfect position to say that, because sometime before I criticized the German Federal Constitutional Court because of his sentence on the Central European Bank, European Central Bank. That was not a good decision. That was not a good jurisprudence. Now I'm very glad to say that this decision of the climate change question is indeed a fantastic, a fabulous court decision. It's a decision that opened doors to the future, opened doors to the protection of human rights. It's a decision of global law, or better, as I prefer to say, as a law without frontiers, environmental law without frontiers, a fundamental right without frontiers that we need nowadays. That's it. Thank you very much.